Good afternoon, everyone, and welcome to LIBOR's Wednesday webinar. It's October and it's fall, and we're glad that you're here with us today. My name is Mary Ann Monteleone, Vice President of Professional Development for LIBOR. LIBOR has earmarked October as Commercial Month, where we'll put emphasis and focus on various aspects of the commercial real estate marketplace. And to start us off this first Wednesday in October is our very own Patrick Fife, LIBOR Associate Counsel for the Long Island Board of Realtors, our 30,000 member Realtor Association. So without further delay, we welcome Patrick on New York Commercial Real Estate Legal Update. And yes, most of these laws do apply to you. Hi, Patrick.
Hey, Marianne, thank you for the intro. Good afternoon, everybody. Yeah, that's my title. Most of these laws apply to you too. For those of you that have been through the commercial update course that I give at LIBOR, some of this material, a lot of it is similar. Because New York doesn't make a distinction, at least the New York Department of State doesn't make a distinction between commercial and residential licensees. You're all one and the same. So there are a couple little nuances when it comes to the law and how things might apply to commercial licensees. But so many of the laws that apply to licensees that handle residential transactions apply equally to commercial practitioners. So it's really important that you understand the laws and in particular, a lot of the new changes in the law that have come into effect over the last year or so. So before I get into the material, I do want to just give everybody a quick overview on how do you stay updated on the law? Because the law in New York is always changing, more so than many other states. New York is a very highly regulated state. This is a very highly regulated industry. So it's really difficult for you to keep track of all this. So what we do at LIBOR is we give you a couple different ways that we try to help you out and give you information that helps you stay on top of changes in the law. The first is we give a legal tip every Friday. So if you don't get Friday's legal tip through LIBOR and the Friday email, go to our website and sign up. You can just go on the bottom of the page. There's a communication opt-in at lirealtor.com. And the other thing we do is we've started this year, we give a free legal update class every week. It's available for continuing education credit. And you can sign up on the website on the education page once a month. And it covers a lot of the material I'm going to cover today. And also any new changes that happen in the law. So it's something that I encourage people to take. I know part of your continuing education obligation requires you to take a legal update class once every 2 years. I recommend taking it more often. I think because the law changes so frequently in New York, it's not enough just to take a class once every 2 years to understand and know what your obligations are. A couple other resources that you might want to check out that we have at LIBOR, our legal page on lirealtor.com, our fair housing page, and also a new initiative, a new website we've created earlier this year, Home for All of Us, that covers a number of fair housing issues with the initial focus on source of income, lawful source of income discrimination, which if you're involved in rentals at all, is something that you need to be familiar with, and we give you a lot of information on that topic there. I also think you should all check out on a regular basis the National Association of Realtors information that they put out. Remember, when you're a member of LIBOR, you're also a member of the National Association of Realtors, and you have access to a ton of great information. If you're a broker, there's a lot of risk management materials that are out there, really informative on a number of federal laws. So I would encourage you to take a look at that. Finally, New York State Association of Realtors. Again, if you're a LIBOR member, you're also a NYSAR member. And they also provide a lot of great material for you. Again, all free if you're a member. So something to definitely take a look at. And you also have access to the NYSAR Legal Helpline. which is 51843 NYSAR. And finally, New York State puts out a lot of great information. I mentioned at the beginning, the Department of State doesn't make a distinction between commercial licensees and residential licensees. You are a licensed real estate salesperson, a licensed real estate broker. That's it. So, if you're in the commercial context, you need to be familiar with all the licensing regulations, the advertising regulations. And New York State puts out a lot of great material there for you to check out as well. So I'm going to now go over some substantive concepts, and I'm going to really talk about how they relate to commercial practitioners. And first question is, well, anti-discrimination laws, do they apply to me as a commercial licensee? Yes. There's a lot of talk about fair housing, but discrimination in the context of commercial transactions is illegal as well. The New York State human rights law provides protection from discrimination in connection with the sale, rental, or lease of land or commercial space. So whether you're dealing with someone's housing accommodation or a commercial space, it is illegal to engage in discrimination. Well, then you might ask me, what about the fair housing laws? Isn't that different? There are fair housing laws in particular. New York State enacted a number of new fair housing laws at the end of 2021, the end of last year. And they were in response to the Newsday Long Island Divided investigation. There was New York State Senate hearings that took place after that investigation. And as a result of those hearings, a number of new laws were passed. And I'm going to go over some of them because they do impact commercial licensees, even though they came about as a result of a fair housing investigation. And so let's talk about those a little bit. The state wanted to focus on three things after the Newsday investigation. They said, the real estate industry needs more broker supervision, better training, and more testing, basically the type of testing that took place in the Newsday article. And all of that has an impact also on the commercial side. And I'll talk about broker supervision first. So New York State, when they looked at broker supervision, they said, we've got to look at what role does an office manager have in the context of a real estate office. And interestingly enough, until last year, the term office manager really wasn't defined in the law. And there was no requirements for being an office manager, at least legal requirements. And there was nothing that the law said about what duty does an office manager have. So the state this year changed the law and said, first, to be an office manager, you have to have been active as an associate real estate broker for 2 of the last 4 years. And I'll repeat this throughout. This doesn't just have to do with residential office managers. This is just office managers generally. You have to have been active as an associate real estate broker for 2 of the last 4 years. And office managers now have the same duty of supervision that the broker does. Until this change was made, there was nothing in the law that said, hey, what does an office manager need to do? Well, now an office manager legally has the same duty of supervision that the real estate broker has. And what is that? Well, the law tells us exactly what that duty of supervision is, and it's regular, frequent, and consistent personal guidance, instruction, oversight, and superintendence by the broker with respect to the brokerage business and all matters relating thereto. So, now we have a system that says if you're going to be an office manager, you have the same duty of supervision that the broker has as to any associated licensees working under that broker. So it's important now that we have that duty, but also, office managers and brokers, they have to think about, well, what procedures do we actually have in place to supervise the actions of the licensees that work under us? So another thing that following the Newsday investigation and Senate hearings the state did with legislation was they came up with something called broker standard operating procedures. And they're standard operating procedures that are required for prerequisites that prospective home buyers need to meet before receiving services. So you're going to sit here and tell me, Patrick, I don't deal with home buyers. I strictly work in the commercial area. I don't do anything residential. I do commercial leasing. I do commercial sales. That's it. Well, I'm telling you that even if that's the case, you still need to have these standard operating procedures. The law applies to all brokers. So even if you're never going to engage in a commercial transaction, you at least have to have these standard operating procedures. You have to display them on your website. I'll explain how. It's just something you have to have in place in the event someone ever walks into your office with the idea of buying a house. Again, it's prerequisite. It's the standard operating procedures for prospective home buyers that are going to come into your office. And every broker in New York State has to have these regardless of the type of work that they do. So what do they have to be? What are these standard operating procedures? It's really pretty simple. The state says it has to address three things. Do prospective home buyers need to show identification? Does your office require an exclusive brokerage agreement? And is pre-approval required, loan pre-approval required before you're going to deal with someone? You just have to answer those three questions, put them in your standard operating procedures, publicize and follow them. The New York State Association of Realtors, NYSAR, created a form broker standard operating procedure. So if you don't already have one and you have to have this in place now, you certainly want to get them in place. And that NYSAR form is available on our website, on our Fair Housing Hub. Again, these apply to prospective home buyers. And the law goes back and forth. It says in one place, prospective home buyers, other places, prospective clients. It's basically anyone who's coming into your office to buy a home. And it's up to the broker then to decide in that standard operating procedures, do we require any or all or some of those three items? And it's up to the broker to decide what they want to put in their standard operating procedures. And once they have them, they have to do two things. One, publicize them, and I'll explain how. And two, follow them. If someone comes into your office, the broker and anyone working under them has to follow those standard operating procedures. So that requires communication. So I mentioned at the very beginning that duty of supervision, part of that duty of supervision requires communication. So the broker should be communicating their standard operating procedures to everyone working under them and making sure that they're being followed. So everyone, every agent, every team working under a broker has to follow those same standard operating procedures. So if a broker doesn't require mortgage pre-approvals before working with a home buyer, then no other agent or team working for that broker can require them. Certainly someone working under the broker could suggest it. They could suggest the benefits of having a mortgage pre-approval, but they could not require it if the broker does not require it. Now, this is something everyone needs to listen up on, even if you do not deal with residential customers on a regular basis or at all. If you're a broker, you still need to have these standard operating procedures, and you still have to have them posted on any public websites, mobile apps, and have them available upon request at all your office locations. Any team website, mobile app also has to post the broker standard operating procedures or have a link to the broker standard operating procedures. And it has to be something that's clear and conspicuous. It can't be something buried, at the bottom of a web page here in the footer. It's got to be in an area where the public can see it and the public can find it. And I'm going to talk about a couple of other things that need to be on all broker websites. And I'll give you a little summary at the end, but this is one of them. Again, even if you don't deal in the residential arena or with residential customers, this is something that the state is requiring you to have on your website. Brokers can change their standard operating procedures. There's a whole process for that. This isn't something that, the broker has to stick with. If a broker wants to make a change, all they need to do is have that change date stamp notarized and post the change to their website or mobile app. So the next thing I'm going to talk about is New York State also has a new disclosure form for reasonable modifications and accommodations in residential housing accommodations. And the question you might get asked, let's say you just do commercial leasing. What does this have to do with me? Well, there are obligations that you have as a real estate licensee with respect to this disclosure, even if you're only doing commercial. And it principally has to do with making sure that this is something, again, that's on your website. However, if you are someone that deals with residential leasing, this is absolutely something that you need to understand, and it's a disclosure that you need to be providing to all prospective tenants. So I say, this disclosure form does create obligations for all brokers. So first, let's understand what is this disclosure? Why is it needed? Why is the state requiring it? Well, it's a disclosure that requires landlords, managing agents, and real estate licensees to provide a reasonable modification and accommodation notice to all prospective and current tenants of housing accommodations at first substantive contact. It is the law right now. And what is a housing accommodation? First, it's really anywhere where someone's going to live, sleep. So if you're involved in leasing any housing accommodations, this is a disclosure form that you have to provide to all prospective tenants at first substantive contact. And why? What is it? What is a reasonable modification, a reasonable accommodation? It's something that is legally required to be offered to anyone who has a disability. And a modification is a structural change. So I give you the example there of a ramp and a handrail. It's a structural change that needs to be made to a housing accommodation, so someone with a disability can use and enjoy the property the same way that someone who's not disabled would be able to. Reasonable accommodation, that's just simply a change to a policy. So again, it's I give you the example here of a service animal, but it could be a variety of things. It could be parking spaces, handicap parking. It could be allowing someone to park closer to the building who has a disability. But it's a change to a policy that, again, allows someone who has a disability the ability to reasonably enjoy the property the same way that anybody else would. So I see Anna's asked the question, and I am going to take a look at the Q&A if I see anything pop up. Anna asks, who's responsible for the handicap accommodations? An accommodation change to a policy, that is the landlord's responsibility, and that's what this notice is for. It's so tenants who are disabled, and it's really any tenant, because you don't know, right, who is disabled. People don't walk in and say, hey, I'm disabled, or it's not necessarily apparent if somebody has a disability. So this notice is to let tenants know you have the right, if you're disabled, to ask for reasonable accommodations and modifications. So accommodations, onus typically on the landlord. Modifications, the cost, and that might be your question, who's responsible for the cost? Typically the cost is on the tenant, but the landlord has to allow it. You as the real estate licensee really shouldn't be getting into the question of whose responsibility it is to pay for it. Those questions, it can be on a case-by-case basis as to whether something is reasonable or not. So in those situations, if questions come up, well, is this something that I have to do? Who's responsible for the cost? The landlord at that point should be consulting, with their own counsel. But as far as cost, typically it is something that is the tenant's cost. It's just the landlord has to allow for it. And there can be issues of what's considered reasonable. I mean, certainly a modification to a structure that would require, basically reconfiguring the entire structure, or that would change the purpose of the structure. That's probably unlikely to be reasonable. But what would be considered a reasonable modification, again, I give you the basic example here, grab bars, handrails, those types of things that are reasonable changes to the structure. Typically the cost would be on the tenant to pay for that. So what's your obligation aside from providing this to any prospective tenant of a housing accommodation? Well, the notice has to be posted on all real estate websites and at all real estate offices. So again, this is something that even if you don't handle residential leases or residential transactions at all, it is something that needs to be on your website and available and posted at your office. Where do you post it on the website? It's really the same thing. It's prominently and conspicuously. So it shouldn't be something that's buried at the bottom of a page that's hard for a member of the public to see. And I make the point again, even if the broker doesn't do rentals, it must post the notice on its website. As far as the office, just in a easily accessible, well-lighted place. So good example would be wherever you post, your real estate license. It's just a notice that you want to have posted in that same spot. So I'm now going to talk a little bit about some other fair housing regulations, and they do also apply to commercial transactions. I caution people because when you hear the word fair housing and you might just immediately think housing, not commercial, that kind of doesn't need to be something I think about. It is. New York's fair housing regulations when it comes to the Anti-Discrimination disclosure form and the New York State Fair Housing Notice are two documents that apply to all real estate transactions. I gave a similar version of this presentation a couple weeks, maybe about a month and a half ago, to some members of our commercial committee. And I think some of them were somewhat surprised to hear this, because it's, again, not something that gets covered too often. But here's New York State's Housing and Anti-Discrimination disclosure form. I hope you're all familiar with it. This is a form that needs to be provided at first substantive contact, and it applies to all properties. I think because it is, it came out in connection with some fair housing regulations back in 2020, there's this perception out there that, again, it only deals with residential, but no, the regulation applies to everything: residential, condos, co-ops, commercial, unimproved vacant property, new construction. There are no exceptions. And what does this do? It's a disclosure form that it tells consumers, about the human rights law. It explains how complaints can be filed. It explains what the real estate licensee can't do. But it's a good opportunity, I think, when you have to provide this form at first substantive contact to every consumer, is to explain, look, not only can I not discriminate, but you can't either. The fair housing laws, anti-discrimination laws, they don't just apply to you, the real estate licensee. They apply equally and with the same force to sellers, to landlords. It's any discrimination in connection, with the sale or leasing of property. So I think it's a really good opportunity for you to sit with your client, explain, not only can I not discriminate, but you can't, and I can't abide by any instructions that you might provide that are discriminatory. So it's a very important form, and I think that's why the state wants it to be provided to every consumer in every transaction at first substantive contact. And what's first substantive contact? Well, it's when you engage in any meaningful way, with that client. So it's, if you're going to be taking a listing, when you start talking about taking that listing, that's first substantive contact. If it's with a prospective tenant or buyer, it's when you begin to talk about price and terms about a particular property, or if it's about possibly showing that person different types of properties that they might be interested in. And first substantive contact doesn't just mean in person. It can mean over the phone. It could even mean via any kind of electronic communication, texting, email. And this, again, is a form that has to be provided once that first substantive contact occurs. And you could provide it in any way other than basically just reading it to the person. So you can send it by email, text, in person, hard copy. And you could even send a link, provided you inform the consumer with clear and conspicuous language that you are providing them information regarding the New York State human rights law. Do you have to get this signed? The answer is yes, if you provide it in hard copy, or if you give it in electronic copy. I don't have my iPad here in front of me. You can't even see it now. I've got my iPhone, but it's disappeared. But if you give it an electronic means for somebody to sign in that fashion, yes, you would have to, in that instance, get it signed. But if you provide it any other way, you do not have to get it signed, but you have to keep a copy of that transmission for not less than 3 years, proof of that transmission. So a copy of the email, a copy of the text, showing that you provided it to the consumer. And again, that record has to be kept for 3 years. So I always caution anytime I talk about this or any kind of record keeping, if you are using a smartphone to communicate and provide disclosures, you absolutely want to make sure 2 things. One, that you don't have a setup where you have your text messages to auto delete after a year. A lot of people have that set up. If you do, you have to make sure that you've got an alternate method of backing up your data. Make sure that your text messages are being backed up before they're being auto deleted. Very important when it comes to record keeping, that you've got a proper document retention policy that's making sure that you're keeping disclosures and transmission, proof of transmission, in this case for not less than 3 years. What do you do if somebody refuses to sign this form? And it can happen. Look, you may provide it to somebody and it's at first substantive contact. At that point, you don't have any formal business relationship with them, right? They may say, I don't sign anything. It's very common. People say that, right? I'm not signing anything you give me. You're trying to trick me. But look, people will do that. And if they don't want to sign it and you have presented it to them in person, they don't need to sign it. But then you have an obligation in that case to complete an oath or affirmation, declaration saying and explaining the facts that you did present this disclosure form, explained what it was, and that the consumer refused to sign it. And you have to maintain that document for no less than 3 years. We have a form declaration that we prepared here at LIBOR. It's on our documents on demand page. So be certain to have that among your forms in the event that you have somebody that refuses to sign the declaration. So the other form I mentioned as part of the New York State Fair Housing regulations that apply equally to commercial practitioners is the New York State Fair Housing Notice. And I know it says housing, but it again is something that applies even in the realm of commercial. So the New York State Fair Housing Notice must be displayed at all offices. every real estate broker, not just real estate brokers who deal with housing, have to display the fair housing notice at every office and branch office. And that means prominently displaying it. It should be in the window. If you don't have access to a window, it should be in the same place that the business license is posted. It also has to be displayed at all open houses of all real property. So it doesn't flow logically, but legally, the requirement is all open houses of all real property. So even if you are having a commercial, you want to call it an open house, open viewing, whatever it might be, this is a notice that should and needs to be posted in an area where everybody would see it, and additional copies of that notice have to be available and provided to consumers when requested. The fair housing notice also has to be prominently and conspicuously displayed on all websites maintained by really anyone, real estate brokers, associate real estate brokers, salespersons, and teams. And again, it has to be a prominently and conspicuously displayed notice. You can have a link to the notice, a link straight to the state's website, but it has to be prominently and conspicuously displayed. And I say all websites, that includes social media. So if you are using your social media page to advertise listings or talk about your licensed real estate activity, that is considered advertising, and that is a website that you have to have a link to the fair housing notice. And again, it should be somewhere above the fold so that the consumer doesn't have to scroll down to find it. So let's recap, because I know I covered a lot when it comes to what has to be on your website. 3 things should be on every real estate website: broker standard operating procedures, the link to the reasonable accommodation and modification notice, and a link to the New York State Fair Housing Notice. And all 3 should be clear and conspicuous. And this does include social media. I've heard people say, hey, Patrick, wait, Facebook, that's my page. I put things about my dog, my vacation, what I had for dinner, what my kids did. That's great. But if you also mix in, hey, I've got this great new listing, come check it out, right? You've made your page advertising when it comes to real estate activity. So at that point, you have to make every effort to, on those pages, have links to these 3 documents. Just so everybody's aware, as an alternative, I mean, the Department of State will allow you to have a link to a separate page where all these disclosures are made. But again, you have to clearly and conspicuously disclose the link's purpose. You can't just say, click here for more information. You'd want to have something to say, click here for broker standard operating procedures, reasonable accommodation and modification notice, and New York State Fair Housing Notice. But these are things that the state can, and I'm sure is looking for. It's very easy for the state to go and just do a inspection of real estate broker websites, and to the extent that you don't have these links, it can very well be $1,000, even a $2,000 fine, because with respect to the fair housing notice, the reasonable accommodation and modification notice, and standard operating procedures, they all relate to fair housing, and the maximum fine for a fair housing violation is now gone from $1,000 to $2,000. So next thing, what are the continuing education requirements for commercial licensees? I'm going to talk a little bit about this, and they're the same. They are the same for commercial and residential. There are no differences. Every real estate licensee in New York needs to have 22.5 hours of continuing education every 2 years. I say this currently includes, I'm going to expand this in a second. because as of about a week ago, it's actually more than this. So you have a core, or you did have a core up until September 21st, that also you needed 3 hours of fair housing, an hour of agency, 2.5 hours of ethical business practices, and 1 hour of legal updates. But the state has now expanded that. So effective September 21st, which means that if your license expires tomorrow or any day thereafter, you also now have to have completed 2 hours of implicit bias training and 2 hours of cultural competency education. And New York State has made this was also part of the laws that went into effect last year, but it is effective now. So if you are renewing your salesperson or broker license tomorrow, you cannot check that box that you have completed your continuing education requirements unless you've completed these 2 courses, 2 hours of implicit bias and 2 hours of cultural competency. LIBOR is giving some of these courses soon. You can check out, these may be, I know these are the ones that were scheduled as of about a week or so ago. We may have a couple more, but go to lirealtor.com/education if you have not taken these courses and you need them in order to renew your license. I'm going to talk a little bit about agency disclosure obligations for commercial properties, because this is an area where there is a little bit of a difference when it comes to commercial and residential properties. So if you handle residential transactions, you should be familiar, and if you're not, you're missing the boat. New York State requires an agency disclosure form for residential transactions. That agency disclosure form is not required for commercial properties. It's only mandated for residential property transactions, including co-ops and condos. And in those transactions, it has to be provided at first substantive contact. So that form is not required for commercial transactions. Royce has a question about, well, why is it different? It's just the way the law is written. It's not something that's required for commercial transactions. However, and this is the however, you do still have a legal obligation to disclose who you're working for or who you're acting for. New York State law does provide, this is New York State regulation, says a real estate broker shall make it clear for which party he is acting. So there's no specific requirement that you use that agency disclosure form, that particular form, but you do need to make a disclosure. You do need to disclose who you're working for, even in a commercial transaction. So a disclosure is required. It just doesn't need to be made using the written agency disclosure form that the state has provided. My guidance would be, even though it's not, that particular form is not required in a commercial transaction, it may be a good idea to have it as evidence if there is a dispute. So again, the specific form, that written form that the state has for residential transactions, is not required, but you do have to make a disclosure. So that may be a form you might want to consider using, or something similar to it, given that you do at least have to make at least some form of disclosure as to who you are representing. So I'm going to talk now about advertising and New York State's advertising regulations as they apply to commercial licensees. And surprise, surprise, there's no difference when it comes to commercial advertising. And I say it's hard to believe, because I see that there are instances, and I don't know if it's just a kind of a thing that people assume that, oh, well, there's different, I could advertise differently in the commercial, the same regulations don't apply. They do. Every advertising regulation that applies to residential applies to commercial. The rules are no different. And This is right from the Department of State guidance, bullet point 2 here. It says commercial and residential brokers are treated no differently under the applicable laws and regulations. So, and this is something I see out there, just me and my own personal kind of day to day. I don't always see, and I'm not picking on commercial folks. I don't always see, whether it's commercial and even some residential licensees, using their correct license title. You have to display your correct license title in your advertisement. So, you have to use licensed real estate salesperson or licensed real estate or real estate salesperson. You don't have to use the word licensed, but you have to use the correct title: real estate salesperson, real estate broker. Using incorrect titles or informal titles like sales agent or just simply saying broker is inappropriate. Here's another big one: corporate titles. You can only use a corporate title if you are a broker of record. So you can't say, I am a vice president, even if somebody calls you that within your office. It's not something you can advertise unless you're the broker of record. Associate brokers and salespersons are not permitted to advertise as corporate officers. So something to be aware of in your advertising. And remember, advertising is broadly defined. So it is any activity. Anytime you are doing things related to your licensed real estate activity, email, advertising on the internet, simply your business cards, signs, everything related to promotion of your licensed real estate activities, advertising. And I repeat it here just because I do think it is very important. Social media is not treated any differently. Department of State isn't going to say, hey, John's Facebook page, he's got really great pictures of his kids and his vacations, so we're going to look at it differently than his corporate website. It's the same when it comes to advertising. If you are going to use that social media as a vehicle for your for advertising your listings. And you should make every attempt to comply. So you can post, certainly like Facebook, for example, if you've got a room at the beginning of your about page, wherever it is, you can put those links to the required disclosures. You could pin a post at the top. It's really not that hard. And I just encourage everyone, hey, every couple of months, take a look at your advertising, take a look at your social media pages. Just make sure that you're hitting, all of the requirements and that you're making all of the required disclosures, because it's really that easy. And because it's that easy, that's why I think, DOS may start looking at places like social media, because it is public, it is out there. It's that easy for them to look and see if you're not making the effort to comply. My last topic, and I see one or two questions that I will try to answer. Remote notarization. It is back, and I think it may be helpful to all of you in the commercial practice as well as the residential practice. Just be aware there's some differences in how remote notarization is going to work starting next year. And I know a couple of you out there may even be notaries as well. So it's really important for those of you that are notaries to listen up to this. If you remember during COVID, during the height of COVID, I know COVID's still out there, but during the height of COVID, when we had the New York on pause, the governor temporarily allowed remote notarization. That then expired. But then earlier this year, the state passed a law and basically made remote notarization permanent. And until January of next year, we can do it the same way we had been doing it during COVID, which is really kind of like through Zoom, where the notary observes the signature identification through any kind of video conferencing platform. That's allowed now. After January, that will not be allowed. There is only going to be something permitted called remote online notarization, RON. So that is going to be where the notary officiates the document remotely through it's like a dedicated audio visual technology platform with security protocols. It's more secure than something like Zoom. So that's something that goes into effect January. So if you are a notary, if you employ the use of notaries regularly, it's something that you should be aware of with respect to that change. And I encourage you to go to the Department of State website to check that out. So I am going to stop my screen share. And I'm finished up with the formal presentation. I now see a question from Frederick about cold calling. So the question is, does this current New York State prohibition on cold calling apply to commercial? Mentions commercial brokers in New York State. So there is a cold call ban in New York State. It remains in effect right now through, I think, at least October 27th is the current date, and it may go on past that. So for those of you that don't know, the state changed the law a couple of years back before COVID that said anytime there's a declared state of emergency, cold calls or telemarketing for goods and services to members of the public is not permitted, and seemed like a good idea. But then COVID hit, and we had a state of emergency that lasted almost 2 years. I don't think anybody ever anticipated that would be the case. That COVID state of emergency is actually expired, but since then we now have a monkeypox state of emergency, a healthcare staffing shortage state of emergency, a polio state of emergency, and a gun violence state of emergency. We have 4 separate states of emergency in New York right now, and they've been renewed by the governor every 30 days or so. So until those states of emergency end, we have a cold call restriction in place. And that prohibits anyone, it's not real estate specific, anyone offering goods or services to members of the public. So if you are calling a member of the public and it's not a business to business call, that would be considered a cold call. So look, there may be instances where it is a business to business call, where you're calling another business about, let's say, a property that they may or may not be selling, and you don't have an identifiable business relationship with them, but they're a business. That's not a cold call. But if you are calling, let's say, I don't know, Joe Smith owns a commercial property. Well, that's a member of the public. And even if you're calling them about a commercial property, I still think in that case it would be a cold call, and it wouldn't be allowed. So again, it's if you're offering goods or services to members of the public until the cold call ban is lifted, it's not allowed. NYSAR, the New York State Association of Realtors, has lobbied, I know, hard to try to get the cold call ban changed, but unfortunately, the state legislature has not been receptive to really anyone at this point. I think they feel maybe if they make an exception for one, they have to make an exception for all. There's been some proposed legislation to try to narrow the scope of the cold call law, or the state of emergency cold call law. It just has not passed in Albany yet. So until those cold call bans are lifted, or the states of emergency are lifted, the cold call ban remains in effect. Jessica has a question. Will we be able to have a copy of the recording? Marianne, I believe we are recording this, right?
I am, and I'm putting
Yep.
the address in the chat for everyone.
Okay. Yeah, and I also so the slides will be part of the recording as well. So you'll be able to see them up on the screen, and any of the links that were there, you should be able to get as well. I think, do we have any other questions, Marianne? I think I answered everything that came up in the Q&A.
I think you did.
Okay. All right, great. So I appreciate everybody's time. Last thing, just so everybody's aware, I know we're going to have some other commercial presentations the rest of this month. So every Wednesday, please be on the lookout for some other programs we have coming up, including one next week, right, Marianne?
Yep. The entire month will be dedicated to commercial real estate and various aspects of it. Next Wednesday, we'll have Mike Kelly, Governmental Affairs Director, speaking on commercial real estate and how the laws apply in his area. He is from the New York State Association of Realtors, and we're thrilled that he could give us this time. Last time Mike presented, he had a huge turnout, so hopefully you'll be with us. I did put in the chat, I answered Jessica's question and I put in the chat the address. It's to view Patrick's webinar along with all of LIBOR's other Wednesday webinars that have been recorded, and they're free to LIBOR members, all there for you. So thank you, Patrick, and
Oh, great. Yeah, thank
everybody
you.
have a great day.
All right. Have a great day, everybody. Thank you.
Thank you.